Glad he made it.
He squeaked in here.
Glad he made it. Good afternoon, Commissioner. Mom, look at that with that nice haircut. Oh man, that must have big day. Big day. 9 o'clock. See, I'm on time. Yes, that's good. I'm late.
If you're on time, you're late.
That's right.
Those here.
All right. Good morning, everyone. This meeting is called to order. Mr. Trobin, is anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
Let's see, no cases to reconsider on agenda item 3. Is that correct?
Yes, sir, that's correct.
Let's look at tax liability cases under agenda item 4. We have no tax cases on docket 29 and 1 tax case on docket 30.
That is correct. One case on docket 30. It's TD-22-006-0422. Commissioner Dennison,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
Thank you.
No fair housing cases on agenda item 5.
Yes, sir, correct.
Under agenda item 6, we have 2 wage claim cases on docket 29 and no cases on docket 30.
That is correct. The first case on docket 29, case number 21-053198-0. Commissioner Alvarez.
The claimant worked as a teacher for the employer, a private school, for 3 years. The parties agreed that the claimant's pay rate was $61,800 per year. While the employment contract shows that the contract term was for a 12-month period beginning August 1st of 2020, it also states that the claimant would only be employed during the academic school year, which is listed as August 10th, 2020 through May 28, 2021. Both parties agreed that her salary was divided in 24 equal installments over a full year, which equates to a semi-monthly payment of $2,575. The claimant's last day of work was May 28, 2021, which was the last day of school. It was also the last day of her employment, as shown in the contract. Therefore, the claimant completely fulfilled her employment duties as agreed to the contract. While the contract states that the payment will be prorated based on the fraction of the employment term worked, employment term was left undefined. The best reading is that the employment term is the term in which the claimant was to provide the duties for which she was employed. This in keeping with the practices of the parties during the 3-year employment, and it is a common practice for teaching employment contracts. In addition, the employee handbook states, salaries have been calculated to reflect all the employees are scheduled to be at school, including teaching days of August through May. Here, the claimant completed the entirety of her employment term and is entitled to the full payment agreed to by the parties. The claimant is entitled to $302.30 for the last 3 days of the May 15th through May 31st, 2021 pay period, and $10,300 for the final 4 pay periods in June and July of 2021. Additionally, the employer admitted the claimant was supposed to be paid in semi-monthly installments of $2,575. However, due to the payroll processing error, her checks were short by $75 each pay period. The claimant is entitled to $750 for 10-day pay periods covered by her claim. Modify the AT wage claim part-timely $11,352.30 wage owed.
The AT decision should be modified. I agree that the wage claim was partly timely and covered any wages due for the period extending 180 days back from her wage claim filing date. Both the claimant and employer agreed that due to a payroll error by the employer's payrolling service vendor, the claimant was underpaid by $750. So it is appropriate to award the difference in wages resulting from the error. Concerning the 3 days at the end of May 2021, the employer was not entitled to reduce her salary for those days since they were all on the Memorial Day weekend, and the claimant was not scheduled to work those days in any event. The claimant is not entitled to additional wages for June and July since her resignation became effective at the end of May, and the compensation agreement provided for a proportional reduction in the salary owed if the contract were terminated early. Accordingly, we should modify the AT decision the wage claim was partly timely and the claimant is entitled to additional wages totaling $1,052.30.
I concur with Commissioner Demerson.
I would agree with the commissioners. Correction. Oh. Short form dissent.
I have your short form dissent, Commissioner Alvarez.
Thank you.
And the second case pulled for docket 29 is case number 21-053-201-3. Commissioner Alvarez.
The claimant worked as a teacher for the employer at a private school for 4 years. The parties agreed that the claimant's pay rate was $59,400 per year. While the employment contract shows that the contract term was for a 12-month period beginning August 1st of 2020. It also states that the claimant would only be employed during the academic school year, which is listed as October 10, 2020 through May 28, 2021. Both parties agreed that her salary was divided into 24 equal installments over a full year, which equates to a semi-monthly payments of $2,475. The claimant's last day of work was May 28, 2021, which was the last day of school. It was also the last day of her employment as shown on the contract. Therefore, the claimant completely fulfilled her employment duties as agreed to the contract. While the contract states that the payment will be prorated based on the fraction of the employment term worked, employment term was left unidentified. The best reading is that the employment term is the term in which the claimant was to provide the duties for which she was employed. This in keeping with the practices of the parties during the 4-year employment, and it is common practice for teaching employment contracts. In addition, the employee handbook states salaries have been calculated to reflect all the days that employees are scheduled to be at school, including teaching days of August through May. Here, the claimant completed the entirety of her employment terms and is entitled to the full payment agreed to by the parties. The claimant is entitled to $225 for the last 3 days of the May 15th through May 31st, 2021 pay period, and $9,900 for the final 4 pay periods in June and July of 2021. Modify the AT wage claim part-timely $10,125 wages owed.
The AT decision should be modified. I agree that the wage claim was partly timely and covered any wages due for the period extended 180 days from her wage claim filing date. The claimant was correctly paid her basic salary up through May 28, 2021. Concerning the 3 days at the end of May 2021, the employer was not entitled to reduce her salary for those days since they were all on the Memorial Day weekend, and the claimant was not scheduled to work those days in any event. Thus, she is entitled to $225 in wages for the last 3 calendar days of May 2021. Just as in the companion case, the claimant is not entitled to additional wages for June and July since her resignation became effective at the end of May, and the compensation agreement provided for a proportional reduction in the salary owed if the contract were terminated early. Accordingly, we should modify the AT decision. The wage claim was partly timely, and the claimant is entitled to additional wages totaling $225.
Modify the AT wage claim timely in part, wages owed of $5,441.54.
I would agree with Chairman Daniel.
Short form dissent.
Yes, sir, Commissioner Demerson. You should have received the wage claim short form dissent list for docket 29 and 30.
Move to accept staff recommendations on the remaining wage claim cases on docket 29 and docket 30.
I second the motion except for those cases of which I'm dissenting as reflected on the wage claim short form dissent list for docket 29 and docket 30.
Her with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 29 and 30.
Motion passes with the exceptions noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 29. Please proceed when you're ready.
The following cases will be read together. Case number 2968933, 2968990.
Excuse me, I'm going to interrupt just a moment. The first case was 2968983.
My apologies.
Please proceed with case number 2.
Case number 2. All right. Case number 2968990, 2968999, 2969007, 3065646, 3066047, 3085903, 3085907, 3085912, 3086048, 3086151, 3086162, 3086234. Commissioner Alvarez.
There is insufficient evidence in these cases to make a decision on chargeback. It is apparent from the records in these cases that the specific facts of each claimant work separation were not developed. The employer in these cases has alleged that the employees were separated due to the pandemic, even though in many cases the employer did not report wages for these claimants during the quarters relevant to the pandemic. These cases should be remanded to address the many inadequacies in their records. With both parties invited. Memo tax to investigate possible SUDA dumping and payrolling. This business operates 9 different store locations, but maintains more than 13 different employer accounts. Despite the appearance of having separate legal entities, the employer has represented that all of the locations are managed and operated by a single entity. A review of commission records reflect that wages are being reported from multiple related accounts for most employees. There is evidence in agency records that this employer may be reporting employee wages under different accounts to manipulate its tax obligation, a practice that is prohibited under agency rules. A Rule 13 decision, TD-15-140-1015, issued in 2016, demonstrates a history of evading tax responsibilities, and their actions since then indicate possible additional violations.
The AT decision in each of the 13 companion cases in this case, in this group, is not supportable. Despite the late protest to the chargeback notice in each case, the employer consistently and credibly testified that the company was misled by what it perceived as assurances from TWC and other state officials that no protest was necessary due to the pandemic. That qualifies the employer for an exception to the timeliness rules, and so the employer's protest to the NMPC in each of these companion cases should be considered timely. Regarding the merits of the chargeback issue, the employer's testimony and other evidence in each case indicates that the claimant stopped working for the named company due to quitting with or without notice while continued work was still available at this company's location. The employer's policy is that any employee can work at any company location, which means that they can go from one employer account to another at will. A voluntary resignation for personal reason qualifies the employer for chargeback protection under section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and protect the employer's account from chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form and memo to tax is referenced in my comments.
Yes, sir. We'll do both of those.
The following group of cases will be read together. Case number 2982119, 2982129, 3065989, 3085741, 3086248. Commissioner Alvarez.
There is insufficient evidence in these cases to make a decision on chargeback. It is apparent from the records in these cases that a specific facts of each claimant work separation were not developed. The employer in these cases has alleged that the employees quit the job, even though in many cases wage records for these claimants continue to show reported wages for one or more entities related to the employer after they supposedly quit. These cases should be remanded to address the many inadequacies in their records. Remand with both parties invited. Memo to tax to determine whether the employer and all employer tax accounts for entities related to this employer are engaging in payrolling and possible SUDA dumping, as well as any applicable penalties under section 204.0 20.87 of the Labor Code.
The AT decision in each of the 5 companion cases in this group is not supportable. Despite the late protest to the chargeback notice in each case, the employer consistently and credibly testified that the company was misled by what it perceived as assurances from TWC and other state officials that no protest was necessary due to the pandemic. That qualifies the employer for an exception to the timeliness rules, and so the employer's protest to the NMPC in each of these companion cases should be considered timely. Regarding the merits of the chargeback issue, the employer's testimony and other evidence in each case indicates that the claimant stopped working for the name company due to quitting without notice while continued work was still available. Voluntary resignation for personal reasons qualifies the employer for chargeback protection under section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and protect the employer's account from chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form amendment of text is referenced in my comments.
Yes, sir, Commissioner Alvarez.
Case number 3086228, Commissioner Alvarez.
There is insufficient evidence to make a decision in this case on chargeback. It is apparent from the record in this case that the specific facts of the claimant's work separation were not developed. The employer has alleged that the claimant quit to move to Houston. However, wage records for the claimant continue to show reported wages for one or more entities related to this employer after the claimant supposedly quit to move. The case should be remanded to address the many inadequacies in its record. Remand both parties invited. Memo to tax to determine whether the employer and all employer tax accounts for entities related to the employer are engaging in payrolling and possible pseudo dumping, as well as any applicable penalties under section 204.087 of the Labor Code.
The AT decision is not supportable. Despite the late protest to the chargeback notice, the employer consistently and credibly testified that the company was misled by what it perceived as assurances from TWC and other state officials that no protest was necessary due to the pandemic. That qualifies the employer for an exception to the timeliness rules, and so the employer's protest to the NMPC should be considered timely. Regarding the merits of the chargeback issue, the employer's representative testified that the claimant quit without notice on November 7, 2019 to move to Houston. In its appeal from the chargeback determination, the employer stated that the claimant quit on September 13, 2019, and in its original protest to the chargeback notice, the employer used the same date of September 13, 2019. The problem is that in appeal number 308-4560 on docket 28, the employer gave the same explanation, i.e. quitting on September 13, 2019 to move to Houston with regard to a different account. Moreover, there is a case involving the same claimant in yet another employer account coming next week on docket 30, in which the employer states that the claimant quit on September 13, 2019 to move to Houston. Due to the AT hearings taking place on different days, it may not have been obvious that the employer was using the same explanation for all 3 work separations. Of course, TWC needs specific information on why each claimant stopped working for each individual employer account on a particular day preceding the initial claim. Accordingly, we should reverse the AT decision on the late protest issue, hold the protest timely, and remand to develop the record on exactly when this claimant stopped working for this employing unit and why.
Reverse the AT, timely response to the NMPC, no chargeback.
We have a majority vote that the response was timely, but no majority vote on the underlying separation.
Let me visit real quick. Tom. Sarah, Chair, I'm sticking with what we have here, remand. My vote really, ATU decision on the late protest issue, hold the protest timely and remand to develop the record on exactly when this claimant stopped working for this employing unit and why.
Okay. Let me rephrase. We have a majority vote to remand on the chargeback separation. What differs is what parties should be invited to the hearing. There's one vote that both parties should be invited to the hearing.
Second. Sure, by inviting both, that's a deviation from what's ever happened before.
Yes,
And-
sir.
And so we'd like to ask General Counsel for a memo on that practice.
You want to hold the case and resubmit pending the OGC memo?
Yes.
Okay.
Well, I would agree that's never happened, but that's not to say it would not happen. We couldn't do it. The two parties couldn't be invited.
So we still have not received a majority vote on what action to take regarding the separation.
Resubmit
Resubmit?
with
Yes,
the
sir.
memo as requested by Commissioner Emerson.
We will do that. Thank you.
Case number 2665400, Commissioner Alvarez.
The claimant should receive a rehearing on the timeliness to determine if the appeal to the commission should be considered timely. In the appeal on record, the claimant alleges having sent appeals to the agency that have not been responded to. This constitutes an allegation of an earlier appeal, and we should grant a rehearing to determine if the claimant sent a timely appeal not received. Rehear on the timeliness of the commission appeal.
The claimant filed her appeal to the commission beyond the applicable deadline to do so. There are no good cause exceptions to the timeliness rules. The claimant did not allege an exception to the timeliness rules, and as such, we should dismiss the claimant's commission appeal as late and leave the underlying decision in full force and effect.
Rehear.
We'll rehear the case.
Case number 2708934, Commissioner Alvarez.
The MR should be granted. Prior to the commission decision, the claimant submitted a complete copy of the severance agreement. This agreement was not fully summarized in the record, and the MR should be granted to consider this information. Additionally, the claimant has provided a letter from the employer explaining that they provided a payment in consideration of the covenants to which the claimant agreed. This itself constitutes new evidence. The agreement in question was highly involved and included release of a claim, confidentiality, indemnification, and other clauses as it placed restrictions on the claimant's ability to work with the employer. The payment did not constitute severance pay under the act. Grant the motion for rehearing, reverse, severance pay eligible, no overpayment.
The claimant's motion for rehearing should be denied. The claimant did not meet the required criteria for a motion to be granted. Consequently, it should be denied. Deny the claimant's motion for rehearing.
Grant the motion for rehearing.
The majority vote that the motion should be granted. We don't have a majority vote yet on what to do with the merits after that. Commissioner Alvarez gave a vote on the merits. Granting the MR without a specific decision on the merits will result in a rehearing being conducted.
That's what I'm asking for.
Okay.
Ms. Miller, I would agree with Chairman Daniel.
We will rehear this case.
Case number 2826609, Commissioner Alvarez.
The decision is not supportable. The claimant separated from employment after she was informed she had been exposed to COVID-19 and began to quarantine. As such, she should be eligible for PUA benefits. Based on the available information, the claimant's work situation required her to work in close quarters with other individuals, some of whom had contracted COVID-19. The claimant lived with her elderly mother, and returning to work at that location would have risked exposing her mother to the virus. Reverse the AT PUA eligible beginning January 3rd of 2021.
The AT decision is supportable. The claimant had filed a valid PUA claim and collected such benefits up through most of 2020. However, near the end of that year, she began working for a small business and resigned from that position due to a general fear of contracting COVID-19 at work and bringing it home to certain family members. While the claimant's concerns were understandable, she did not allow any of the eligibility requirements of the PUA program under federal law. Her resignation occurred in the first week of January 2021, and so it was appropriate for the AT to hold her ineligible as of January 3rd, 2021. Accordingly, we should affirm the AT decision. The claimant is ineligible for PUA benefits beginning January 3rd, 2021.
Affirm the AT PUA not eligible beginning January 3rd, 2021.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2864395, Commissioner Alvarez.
The AT decision should be reversed. The claimant received a lump sum payment after she was laid off by the employer. The payment was conditioned upon the claimant signing a waiver of claims against the employer. Because the parties executed a contractual waiver of claims, the payment is not considered disqualifying severance under the Texas Unemployment Compensation Act. Reverse the AT, no severance, ineligibility, no overpayment.
We should affirm the appeal tribunal decision. The record shows that the claimant received severance pay covering a period of 24 weeks after her separation on September 25th, 2020. Both parties agree that the severance payment was meant to cover that specific number of weeks. As such, the claimant was properly disqualified for 24 weeks after her separation. We should affirm the AT decision, severance disqualification from October 11th, 2020 through March 13th, 2021. Overpayment of $5,350.
Rehear to determine when the claimant received the lump sum payment.
I would agree to rehear.
We will rehear the case.
Case number 2883819, Commissioner Alvarez.
The AT decision should be modified. I do not dispute that the claimant did not establish good cause for his non-appearance at the AT1. On the merits, the information before the agency establishes that the claimant stopped working and earning wages for at least 2 weeks because he tested positive for COVID. He therefore filed a valid claim as an unemployed individual. It is correct that the claimant was ill with COVID, then he likely would be considered unable to work and therefore ineligible for regular UI benefits. However, he may be entitled to PUA benefits, which he would not be able to receive if he is considered not unemployed. Therefore, I am also requesting an investigation of both the claimant's ability to work and ability to work and eligibility for PUA benefits. Modify the AT, no good cause for the non-appearance at AT1, valid claim, recompute the overpayment, memo to UIA and OS to determine whether the claimant was able to work and also whether he was eligible for PUA benefits.
We should affirm the appeal tribunal decision. Regarding good cause, the claimant missed the hearing because he failed to update his address with TWC. Since the claimant was not prevented from participating due to circumstances beyond his control, he did not establish good cause for his non-appearance. As to the merits, the available evidence includes the employer's response to the claim notice, which stated that the claimant was not laid off and was still employed. This supports the conclusion that the claimant was not unemployed when he filed his claim. Lastly, because the claim was not valid, the overpayment was appropriate. We should affirm the AT decision. The claimant did not have good cause for his non-appearance. Invalid claim, overpayment $734.
Modify the AT, claimant established good cause for AT1, resubmit.
We have a majority vote that the claimant did not establish good cause, but not a majority vote on the merits.
Ms. Miller, can you clarify Commissioner Demerson's vote?
Commissioner Demerson voted that the claimant did not establish good cause, that the claim was invalid, and the overpayment should be affirmed. If we're unable to achieve a majority vote, the logical result would be leaving the AT decision in effect.
Ms. Miller, I would agree with Chairman Daniel.
Yes, sir. We will resubmit the case.
Case number 2895323, Commissioner Alvarez.
The A2 decision on the good cause should be reversed. The claimant did not attend the AT1 hearing because she had complications in her pregnancy, and she was in and out of the hospital during the time in which the notice of telephone hearing was sent and the hearing was held. She established good cause for her non-appearance, and her petition to reopen should be granted. Reverse the AT, claimant had good cause for her non-appearance, and resubmit on merits.
We should affirm the appeal tribunal decision regarding the good cause issue. The claimant was not checking her emails, checking her mail. As the appellant, the claimant should have known she needed to have been monitoring her mail regularly. Because the claimant was not prevented from participating due to circumstances beyond her control, she did not establish good cause for her non-appearance. As to the job separation, the available evidence established that the claimant quit because she was asked one time to pick up equipment on the COVID floor. The record indicates that the claimant refused the task and quit immediately without addressing the issue with the employer. Since the claimant quit without first giving the employer a reasonable opportunity to remedy her concern, she quit without good cause connected with the work. We should affirm the AT decision. The claimant did not have good cause for a non-appearance, voluntary leaving, reimbursing the employer not billed.
Reverse the AT, claim established good cause for AT1, resubmit.
We will resubmit the case.
Case number 2904607, Chairman Daniel.
Commissioners previously voted that the employer established good cause because the commission communicated to the public on multiple occasions, including April 1st, 2020, that no employer would be charged based on separations caused by the pandemic. The employer could have reasonably relied upon that information, leading the employer to appeal late. The appeal should be deemed timely and the case should be resubmitted for merits testimony. So reverse the AT, employer established good cause for AT1, timely response to the NMPC, resubmit.
Sir,
No, I'm good.
okay, Commissioner Alvarez.
The employer was unable to provide evidence that they responded to the notice of maximum potential chargeback during the response period and could not say when they submitted the protest. There is insufficient evidence to overturn the findings of the late protest. Modify good cause, late response to notice of maximum potential chargeback.
The AT decision is not supportable based on the current record. I agree that the employer had good cause for missing the first hearing. Concerning the merits of the late protest issue, the employer's testimony and other evidence offered so far do not meet the requirements under Rule 32 for establishing the timely filing of a document that TWC never received. Available documentary evidence indicates a filing date prior to the issuance of the actual chargeback notice, and the employer was unable to give any firsthand testimony showing exactly when the protest was filed. However, the employer has not yet had the opportunity to submit its phone records, which would be independent proof of when the employer actually faxed its protest. Accordingly, we should rehear this case for the purpose of obtaining the employer's phone and fax records that would show exactly when the protest was faxed, that the employer testified was faxed in a timely manner.
We have majority vote that the employer established good cause for missing AT1. We have not achieved a majority vote on the merits.
I concur with Commissioner Demerson.
We will rehear the case. Thank you.
Case number 2990408, Chairman Daniel.
The record reflects the requirements were met for granting a motion for rehearing. Grant the motion for rehearing.
The motion for rehearing should be denied. The employer's appeal did not offer any new evidence. Therefore, it does not meet the criteria for granting a new hearing. Also, the employer stated that their prior appeal was late because the employee who picked up their mail was out of work. That admission does not constitute an allegation of late or non-delivery of an agency document such that a rehearing on the timeliness would be warranted. Deny the motion for a rehearing.
Unfortunately, the employer's motion for rehearing should be denied since it offers no new evidence concerning the fundamental problem relating to its late appeal to the commission from a decision that affirmed an earlier late protest determination. Its explanation for the late commission appeal, i.e. that it was short-staffed and could not check its mail on time, does not qualify for an exception under Commission Rule 32, especially in light of the fact that at the time of the late appeal, December 2021, the pandemic-related problems with mail, phones, and staffing had largely receded. Accordingly, I reluctantly concur in the decision to deny the employer's motion for rehearing.
Yes, sir.
Case number 3048017, Commissioner Alvarez.
The AT decision should be reversed. The claimant's appeal was timely because she filed an appeal on the same day that the determination was issued. On the merits of the separation, the claimant should be held qualified. She left her job because she suffered a number of health problems, including COVID-19 and kidney failure. It would have been a threat to public safety for the claimant to continue working as a driver under those conditions. The claimant left the job due to her health condition and should not be disqualified. Reverse the AT, timely claimant appeal, no voluntary leaving.
We should modify the appeal tribunal decision. First, I agree that the claimant filed a timely appeal. As to the job separation, the claimant quit for health reasons, but admitted that she was not advised by her doctor to quit. It was her choice. Thus, the claimant quit under disqualifying circumstances. We should modify the AT decision, timely claimant appeal, voluntary leaving.
Modify the AT, timely claimant appeal, voluntary leaving.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3056371, Commissioner Dimerson.
The appeal tribunal decision should be reversed on timeliness. The charge liability decision was not received by the employer until the final day of the appeal period. The employer's delay in responding to the decision was not due to negligence. Since the appeal period for a charge liability decision is 14 days, receiving the said decision on the final day of the appeal window effectively limited the employer to a one-day appeal deadline. Because the employer responded as quickly as possible to the decision in question, and because the employer did not receive the decision until the final day of the deadline, we should reverse the AT decision on timeliness. Timely employer appeal, remand.
I would agree with Commissioner Dimerson.
Agreed.
And just to clarify, there's a unanimous vote that the appeal was timely and we're remanding on the NMPC issue. Thank you.
Case number 3067637, Commissioner Dimerson.
The AT decision is not supportable. In similar cases this year, we have held that lack of proper information can be just as misleading to a party as improper information that is given to a party. In this case, the employer was not told on the notice of maximum potential chargeback that it could have dealt with its claim volume problem by simply sending TWC a spreadsheet of all the NMPCs that it needed to protest. That is certainly an option that is available, and it should have been mentioned on the NMPC, particularly in the context of the pandemic, when claimants, employers, and TWC were all overwhelmed by the volume of claims, appeals, and related proceedings. If the employer had had the proper information, it could have responded to the chargeback notice on time. Regarding the chargeback issue, the employer gave testimony on the merits of the work separation so that would be available for review. Accordingly, we should reverse the AT decision on the timeliness issue. The employer filed a timely response to the chargeback notice and then resubmit the case on the work separation and chargeback issues.
The AT decision should be affirmed. The employer uses a third-party representative to process their unemployment claims. The employer testified that they timely received the agency's notice, but they filed the response nearly 3 months late because they did not have sufficient personnel to process their work. The circumstance was completely within the employer's control, and there is no good cause exceptions for the agency timeliness rule. Affirm the AT, no timely employer response to the notice.
Reverse the AT, timely response to the NMPC resubmit.
We will resubmit the case.
Case number 3114946, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I do not contest the validity of claim issue. Concerning the job separation, the claimant was terminated when he refused to comply with the employer's job expectations. Although the claimant was advised about the job demands, which included completing assigned daily tasks and working the occasional weekend, he asserted personal reasons for refusing to fulfill the employer's job expectations. Since the claimant had previously met the employer's job requirements, but thereafter refused to comply with the demands of the job, the claimant mismanaged his position of employment. Hence, we should modify the AT decision, valid initial claim, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. Regarding validity, the claimant was fired prior to filing his initial claim for benefits. Therefore, he filed a valid claim. Regarding the separation, the claimant was fired for refusing to agree to a material change in hiring agreement. The employer asked the claimant to change his schedule and make himself available during later hours during the week and also on weekends. The employer's testimony clearly states that the claimant was not previously asked to work those extended hours and that the employer knew that the claimant did not want to make the schedule change because of childcare issues, since he took care of his daughter during those times. Commission precedents holds that a claimant's refusal to accept a significant scheduling change is not misconduct. Affirm the AT, valid claim, no misconduct, chargeback.
Affirm the AT, valid claim, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3116633, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The employer's policy prohibited violence in the workplace. The claimant was terminated when he instigated and thereafter engaged in an altercation with a coworker at the employer's place of business. The employer, through several firsthand witness statements, showed that the claimant had prompted and thereafter began the physical altercation with his coworker. Since the claimant acknowledged that the employer's workplace violence policy and thereafter engaged in an altercation with his coworker, the claimant's conduct was mismanagement of his position of employment and was misconduct connected with the work. Hence, we should reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, if my fellow commissioners do not agree, I would also support a vote to rehear this case to obtain firsthand testimony from the employer's witnesses and to develop the record about the circumstances which led to the claimant's separation.
The AT decision should be affirmed. The claimant was fired for fighting with a coworker at the office. The claimant credibly testified that he was the victim of an unprovoked attack, and the record shows that he informed his supervisor of the incident after it happened. The employer provided no firsthand witness of the incident or statements from any uninterested parties. Also, the employer testified that a video of the incident showed that the other employee initially struck the claimant. Therefore, the employer has not demonstrated that the claimant committed misconduct. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez. That was the last case pulled for additional discussion on docket 29. You should have received the UI short form dissent list for docket 29.
I move we accept staff recommendations on the remaining UI cases in docket 29.
I second the motion except for those cases of which I'm dissenting as reflected on the UI short form dissent list for docket 29.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 29.
Motion passes with the exceptions noted.
Thank you. Proceeding to docket 30.
The following cases will be read together. Case number 296-8590, 296-8613, 296-8623, 296-8642, 298-0447, 308-1702, 308-2345, 308-2349, 308-2525, 296 8969, 296, 8977, 297, 1871, 297, 1896, 297, 1910, 297, 2234, 297, 2246, 308, 6259, 308, 6286, 308, 6403, 308, 6436, 308, 6449, 308, 6456, 308, 7214. Commissioner Alvarez?
Although I do not agree with the findings that the employer protest was timely due to the misunderstanding, I will not contest at the issue at this time. As to the chargeback issue, the record was not developed regarding the separation from the relevant employer. The claimant in these cases performed services for multiple separate legal entities operated together. The employer has provided testimony and evidence regarding their separation from the last location they worked prior to the pandemic and not the named employer in these cases. The employer in these cases has alleged that the employees were separated due to the pandemic, even though in many of these cases did not report wages for these cases, these claimants, during quarters relevant to the pandemic. It would be inappropriate to issue decisions on chargeback in these cases where the relevant separation has not been addressed. These cases should be remanded to address an inadequate record. Given the issue with multiple chargeback cases involving this employer and its related entities and the employer's refusal to provide specific facts about its employee separation, the claimant should be invited to any further hearings so that the necessary information can be obtained. Remand with both parties invited. Additionally, this business operates 9 different store locations but maintains more than 13 different employer accounts. Despite the appearance of having separate legal entities, the employer has represented that all the locations are managed and operated by a single legal entity. A review of commission records reflects wages are being reported from multiple related accounts for most employees. There is evidence in agency records that this employer may be reporting employee wages under different accounts to maintain its tax obligation. Manipulate, I should say, its tax obligation, a practice that is prohibited under agency rules. A Rule 13 decision, TD-15-140-1015, issued in 2016, demonstrates a history of evading tax responsibilities, and their actions since then indicate possible additional violations. Memo to tax to determine whether the employer and all employer tax accounts for entities related to this employer are engaging in payrolling and possible pseudo dumping, as well as any applicable penalties under Section 204.087 of the Labor Code.
The AT decision in each of the 23 companion cases in this group is not supportable. Despite the late protest to the chargeback notice in each case, the employer consistently and credibly testified that the company was misled by what it perceived as assurances from TWC and other state officials that no protest was necessary due to the pandemic. The employer's protest to the NMPC in each of these companion cases should be considered timely. Regarding the merits of the chargeback issue, the employer's testimony and other evidence in each case indicates that the claimant stopped working for the named company due to quitting with or without notice, while continued work was still available at this company's location. The employer's policy is that any employee can work at any company location, which means that they can go from one employer account to another at will. A voluntary resignation for personal reasons qualifies the employer for chargeback protection under Section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and protect the employer's account from chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Ms. Miller, short form memo to reference in my comments.
Yes, sir, Commissioner Alvarez.
The following cases will be read together. Case number 297-5 5727 298 0460 306 5739 308 1773 297 3835 297 3902 297 3912 297 3922 306 5734. Commissioner Alvarez.
Although I do not agree with findings that the employer's protest was timely due to their misunderstanding, I will not contest that issue at this time. As the chargeback issue, the record was not developed regarding the separation from the relevant employer. The claimant in these cases performed services for multiple separate legal entities operated together. The employer has alleged claimants quit. However, in many cases, wage records show reported wages for the claimants for one or more entities related to the employer after the separation. These cases should be remanded to properly address the separation. Given the issue with multiple chargeback cases involving this employer and its related entities and the employer's refusal to provide specific facts about the employee separations, the claimant should be invited to any further hearings so that necessary information can be obtained. Remand with both parties invited. Additionally, this business operates 9 different store locations, but maintains more than 13 different employer accounts. Despite the appearance of having separate legal entities, the employer has represented that all the locations are managed and operated by a single legal entity. A review of commission records reflects wages are being reported from multiple related accounts for most employees. There is evidence in agency records that this employer may be reporting employee wages under different accounts to maintain its tax obligation, a practice that to manipulate its tax obligation, a practice that is prohibited under under agency rules. A Rule 13 decision, TD-150-140-1015, issued in 2016, demonstrates a history of evading tax responsibilities, and their actions since then indicate possible additional violations. Memo to tax to determine whether the employer and all employer tax accounts for entities related to this employer are engaging in payrolling and possible suited dumping, as well as any applicable penalties under section 204.087 of the Labor Code.
The AG decision in each of the 9 companion cases in this group is not supportable. Despite the late protest to the chargeback notice, in each case, the employer consistently and credibly testified that the company was misled by what it perceived as assurances from TWC and other state officials that no protest was necessary due to the pandemic. The employer's protest to the NMPC in each of these companion cases should be considered timely. Regarding the merits of the chargeback issue, the employer's testimony and other evidence in each case indicates that the claimant stopped working for the named company due to quitting without notice while continued work was still available. A voluntary resignation for personal reason qualifies the employer for chargeback protection under section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and protect the employer's account from chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form and memo as referenced in my comments.
Yes, sir, Commissioner Alvarez.
Case number 3086442. Commissioner Alvarez.
Although I do not agree with finding that the employer's protest was timely due to their misunderstanding, I will not contest that issue at this time. As to the chargeback issue, the record was not developed regarding the separation from this employer. The employer has provided the claimant worked until September 13, 2019, at which time he quit to move to Houston. The claimant's wage record shows his last performed service for the named employer in the first quarter of 2019. It is clear that the facts involving the claimant's separation from this employer were never developed. It would be inappropriate to issue a decision on chargeback in these cases where the relevant separation has not even been addressed. This case should be remanded to address the correct separation. Since this case involves multiple related entities and the employer has failed to provide facts regarding the correct separation, the claimant should be invited to any further hearings so that the necessary information can be obtained. Remand with both parties invited. Additionally, this business operates 9 different store locations but maintains more than 13 different employer accounts. Despite the appearance of having separate legal entities, the employer has represented that all the locations are managed and operated by a single legal entity. A review of commission records reflects wages are being reported for multiple related accounts for most employees. There is evidence in agency records that this employer may be reporting employee wages under different accounts to manipulate its tax obligation, a practice that is prohibited under agency rules. A Rule 13 decision, TD-15-140-1015, issued in 2016, demonstrates a history of evading tax responsibilities, and their actions since then indicate possible additional violations. Memo to tax to determine whether the employer and all the employer tax accounts for entities related to this employer are engaging in payrolling and possible pseudo dumping, as well as any applicable penalties under section 204.087 of the Labor Code.
The AT decision is not supportable. Despite the late protest to the chargeback notice, the employer consistently and credibly testified that the company was misled by what it perceived as assurances from TWC and other state officials that no protest was necessary due to the pandemic. That qualifies the employer for an exception to the timeliness rules, and so the employer's protest to the NMPC should be considered timely. Regarding the merits of the chargeback issue, the employer's representative testified that the claimant quit without notice on September 13, 2019 to move to Houston. In its appeal from the chargeback determination, the employer stated that the claimant quit on September 13, 2019. And in its original protest to the chargeback notice, the employer used the same date of September 13, 2019. The problem is that in appeal number 308-4560, 308-4560 on docket 28, and in appeal number 308-6228, 308-6228 on docket 29, the employer gave the same explanation, i.e. quitting on September 13, 2019 to move to Houston with regards to two other related accounts. Due to the AT hearing taking place on different days, it may not have been obvious that the employer was using the same explanation for all three work separations. Of course, TWC needs specific information on why each claimant stopped working for each individual employer account on a particular day preceding the initial claim. Accordingly, we should reverse the AT decision on the late protest issue, hold the protest timely, and remand to develop the record on exactly when this claimant stopped working for this employing unit and why.
I concur with Commissioner Demerson.
We will remand the case. And Commissioner Alvarez, did you have a dissent?
Short form dissent and memo as referenced in my comments.
Yes, sir.
Case number 2612792, Commissioner Alvarez.
This case should be remanded because the prior employer erroneously submitted wage records with the incorrect social security number for the claimant. The commission required the claimant to verify her social security number. The claimant since has provided a copy of the front side of her social security card, the W-2 from the employer that reported the erroneous social security number, a letter from the social security office correcting the error, and a W-2 from a different employer with the correct social security number, matching the one on her card and in agency records. The claimant has not been afforded a hearing so that she could have this documentation entered into the record and establish her correct social security number. The agency failed to protect her due process rights, and the case should be remanded at the AT to hold a hearing in this case. Remand.
The claimant's appeal to the commission should be dismissed as late because she filed her appeal beyond the applicable deadline to do so. There are no good cause exceptions to the timeliness rules. Accordingly, we should dismiss the claimant's appeal as late and leave the underlying decision in full force and effect.
Late commission appeal, the AT decision remains in full force and effect.
And just to clarify, you're agreeing with Commissioner Demerson?
Yes.
Ms. Miller, short form and memo to UIA and OS to contact the claimant for documents to verify her social security number.
Yes, sir.
Case number 2701763, Commissioner Alvarez.
The decision is not supportable. The claimant was misinformed by TWC representative as to when he could file his appeal. The claimant delayed his appeal based on the misinformation. As such, his appeal should be deemed timely and this case resubmitted. Reverse the AT, timely appeal, and resubmit.
We should affirm the AT decision. Although the claimant alleged good personal reasons for not filing a timely petition to reopen, The record shows that the appeal tribunal decision was mailed to the claimant's correct address of record. Since the record failed to show any indication of a timely appeal within the 14-day appeal period, and because the claimant offered insufficient explanations for his late appeal, we should dismiss the claimant's petition to reopen, affirm the AT decision, untimely petition to reopen, voluntary leaving, no chargeback.
Reverse the AT, timely petition to reopen, resubmit.
We will resubmit the case.
Case number 3040267, Commissioner Alvarez.
The AT decision should be set aside and the separation in this case voided. The claimant gave customer rides in his vehicle for free. He used the Uber app to obtain customers. The claimant ceased his self-employment because of a car wreck. Since he was self-employed, the claimant did not work in employment and did not have a work separation. Set aside the appeal tribunal decision, void the separation determination, no work separation.
We should affirm the appeal tribunal decision. First, I agree that the claimant filed a valid claim. As to the job separation, the claimant quit due to having lost the transportation necessary to perform his job. Because the claimant quit for a personal reason, he quit without good cause connected with the work. We should affirm the AT decision, valid claim, voluntary leaving.
Affirm the AT, valid claim, voluntary leave.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3062519, Commissioner Alvarez.
I do not contest that the employer had good cause to reopen the hearing. Regarding the separation, the employer, a temporary help firm, alleged that the claimant failed to comply with the reporting policy. The employer has not provided the policy. The claimant called HR and confirmed she was available. The employer failed to explain how the claimant's contact did not meet their requirements. The claimant was laid off when the employer failed to find her additional assignments. Modify the AT, good cause, no misconduct, chargeback, void adequate response.
The appeal tribunal decision should be modified. First, I agree that the employer had good cause for its non-appearance, since it was unable to participate in the hearing due to a technical issue that was beyond its power to control. As to the job separation, the claimant failed to report back to the employer, a temporary help firm, for further assignment. The weight of the credible evidence establishes that the claimant was aware of the procedure to report for a new assignment and that unemployment benefits could be affected for failing to do so. As such, the claimant quit without work-connected good cause. We should therefore modify the AT decision. The employer had good cause for its non-appearance, voluntary leaving, no chargeback, sever adequate response.
Modify the AT, employer established good cause for AT1, no misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir, Commissioner Jimerson.
Case number 3070434, Commissioner Dimerson.
We should modify the appeal tribunal decision. The claimant was discharged after exceeding the number of absences allowed under the employer's point-based attendance policy. I do not dispute that the majority of the claimant's absences were unavoidable due to the claimant's personal issue, illness. As such, the claimant's separation was not for misconduct connected with the work. Hence, the employer's account should not be subject to chargeback, as the separation was directly caused by medically verified illness. We should modify the AT decision, no misconduct, no chargeback, MVI.
I would agree with Commissioner Dimerson.
Agree.
Thank you. We have a unanimous decision.
Case number 3072888, Chairman Daniel.
The employer's appeal timeframe occurred when TWC systems were overwhelmed, and because the commission communicated to the public on multiple occasions, including April 1st, 2020, that no employer would be charged based on separations caused by the pandemic. The employer could have reasonably relied upon that information and been misled into failing to appeal. The appeal should be timely and resubmitted. Reverse the AT, timely response to the NMPC, resubmit.
Commissioner Alvarez.
The AT decision should be affirmed. The employer filed a later protest to the notice of maximum potential chargeback. The employer made no allegations of late delivery or non-delivery of an agency document. The employer's testimony that they were unable to access their online account is irrelevant because the agency's notice was sent via U.S. mail since the employer had not selected to receive electronic correspondence. Affirm the AT late response to notice of maximum potential chargeback and correct typo.
The AT decision should be reversed. The employer's response to the MPC was late due to a cluster of pandemic-related circumstances that were beyond the employer's control. including mail and electronic access issues, near total closure of the business, and difficulty reaching TWC to obtain assistance. Such issues affecting the party's ability to receive copies of notices or to obtain assistance justify the one-time exception to the timeliness rules that the commission has been recognizing for certain types of late protest cases. It would be proper to hold the employer's late protest timely. However, we do not have information regarding the reason why the claimant stopped working for this base period employer prior to the initial claim date. Accordingly, we should reverse the AT decision. The employer filed a timely protest, resubmit on the merits of the relevant work separation.
Thank you. We will resubmit the case.
Case number 307-9210, Chairman Daniel.
Because the commission communicated to the public on multiple occasions that no employer would be charged based on separations caused by the pandemic, the employer reasonably relied upon that information and was misled into failing to appeal timely. The appeal should be deemed timely and the case should be resubmitted. Reverse the AT, timely AT appeal, resubmit on the MP, NC, and chargeback issues.
Commissioner Alvarez.
The 18 should be affirmed. The employer admitted filing a late appeal. The employer testified that their appeal was late because they were understaffed. There are no good cause exceptions to the agency timeliness rules. Affirm the AT, late employer appeal, late response to notice of maximum potential chargeback.
With great reluctance, I must conclude that there is no way under current statute or TWC rule to hold the employer's late appeal timely. Although the employer's late response to the chargeback notice may be overlooked due to its confusion based on misleading information from TWC in April 2020 over whether a response was necessary, that same rationale cannot apply to a late appeal over a year and a half later. By that time, numerous clarifications had already been issued by TWC regarding the need to respond to all claim notices and determinations in a timely manner. None of the commission's statements regarding chargeback protection mentioned anything about parties not needing to file appeals. And the chargeback determination clearly indicated that an appeal would be necessary within 14 calendar days. Moreover, the employer explained its late appeal by stating that it opened its copy of the chargeback determination a week after the deadline because it was understaffed. Commission has accepted pandemic-related understaffing and omission of information related to multiple claim responses as a reason for overlooking a late chargeback notice response, but that does not apply to late appeals. I greatly sympathize with the employer situation, but we cannot ignore the plain meaning of our own statute and rule regarding timeliness of appeals. Reluctantly, we should affirm the AT decision. The employer's appeal from the appeal tribunal was late.
Majority vote is that the appeal was late.
Short form dissent.
Yes, sir.
Chair, I also want to add a long file. I also like to file a long form concurrent opinion with the decision on this case.
Long form concurrence.
Long form concurring.
Thank you. And short form dissent, Chairman. Yes, sir.
Case number 308-3398, Commissioner Alvarez.
The AT decision is not supportable. The claimant was ineligible for extended benefits because it was held that she did not make a systematic and sustained work search when she made all her required weekly work search contacts on one day. The claimant made the required number of work search contacts in different methods with different prospective employers and for different positions for which she would be qualified. The claimant made a systematic and sustained work search effort, and she should be eligible for benefits. Reverse the AT, eligible for extended benefits beginning 8/15/20, no overpayment.
We should affirm the appeal tribunal decision. The record shows that the claimant was aware of the extended benefits work search requirement, which required claimants to engage in systematic and sustained efforts to obtain work. The claimant did not satisfy the work search requirements when she failed to utilize the available resources for contacting potential employers for work. Moreover, the record shows that at various times, the claimant had attempted to satisfy her work search requirements in a single day. Since the claimant was aware of the extended benefits work search requirements, but thereafter failed to engage in systematic and sustained efforts to obtain work, we should affirm the AT decision. Extended benefits ineligible beginning August 15, 2021. Overpayment of $1,032.
Reverse the AT. Claimant's eligible for extended benefits, no overpayment.
Short form dissent.
Yes, sir, Commissioner Dimmerson.
Case number 3086747, Commissioner Dimmerson.
We should reverse the appeal tribunal decision. The claimant was discharged after he was involved in a second preventable accident while operating a forklift at the employer's facility. Although the claimant attempted to blame the accident on the alleged faulty design of the forklift, this argument is not persuasive. The claimant admitted that he didn't move his foot over enough when trying to step on the pedal of the forklift, which caused the accident. Additionally, the claimant was still under a safety improvement plan after previously being involved in a similar forklift accident, which provided that any further such accidents would lead to termination. Since the claimant should have known to operate the forklift with more care, his second preventable accident while operating the forklift was mismanagement of his position of employment and was misconduct connected with the work. We should reverse the appeal tribunal decision. Misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The claimant was discharged after a forklift that he was driving collided with another forklift. The claimant provided firsthand testimony that he was not at fault in the in the accident due to a design flaw. The claimant has previously reported the issues with the forklifts and the design flaw to upper management multiple times prior to this incident. The employer discharged the claimant because he had been involved in prior forklift accidents. However, the employer did not offer any evidence to show that the claimant was at fault in the final incident. Since the employer has failed to show that the claimant was at fault, the accident did not constitute misconduct connected with the work. Under these circumstances, the claimant was discharged for reasons other than misconduct connected with the work. Affirm the AT, no misconduct chargeback.
Affirm the AT, no misconduct chargeback.
Short form dissent.
Yes, sir, Commissioner Dimmerson.
Case number 3109026, Commissioner Dimmerson.
The AT decision is fully supportable. The claimant was fired for his complete refusal to cooperate in any way with the employer's COVID-19 health and safety policy. After he refused to become vaccinated against COVID-19, the employer offered him a reasonable accommodation, i.e. he could wear a mask at work and undergo weekly testing for the virus. Such accommodations were in line with CDC and EEOC guidelines at the time for employers and employees. The claimant refused to go along with the offered accommodations because he did not believe in the science behind the CDC's recommendations. The employer's testimony and email documentation show that the claimant also refused to apply for an exemption from the testing requirements. This was not a case of an employer violating the governor's order prohibiting vaccine mandates, since the employer offered the claimant the opportunity to apply for an exemption and a reasonable alternative to vaccination. The claimant's complete refusal to make any attempt to comply with the policy or the accommodation was misconduct connected with the work. Concerning the adequate response issue, the employer's claim response was adequate under our rules. Accordingly, we should affirm the AT decision. Misconduct, no chargeback. The employer filed an adequate response.
The AT decision should be modified. The claimant was discharged after the employer implemented a mandatory COVID-19 vaccine policy, which constituted a change in his hiring agreement. The claimant objected to the vaccine due to health concerns. The claimant's refusal to agree to the change in hiring agreement was not misconduct connected with the work. Therefore, the claimant was separated for non-disqualifying reasons. Since the separation was related to measures dealing with COVID-19 pandemic, I can support protecting the employer's account. Modify the AT, no misconduct, no chargeback due to disaster, void adequate response.
Modify the AT, misconduct, no chargeback, sever adequate response.
Do you agree to sever the adequate response, sir?
Yes.
Thank you.
Short form.
Yes, sir.
Case number 3149937, Commissioner Alvarez.
The record established that the agency received written communications from the claimant via email within the statutory appeal deadline. The claimant's appeal specifically referenced the case and requested her information be forwarded to the appeals tribunal. The claimant received a response explaining that the documentation could be sent to an email address, but the response did not explain that her appeal would not be forwarded or that it would not be considered a timely appeal. The appeal tribunal effectively held that the claimant's appeal was not timely because it was not sent to the right TWC department. Such a narrow and strained ruling is inconsistent with the statutory intent of the act to protect the party's appeal rights. Therefore, the appeal should be considered timely appeal, and the case should be resubmitted on the merits. Reverse the AT, timely appeal, and resubmit.
We should affirm the appeal tribunal decision. The claimant's appeal was more than 2 weeks late. The claimant opened the determination in question on the same day that it was issued. She had ample time to file her appeal using one of the acceptable methods noted, which did not include email. Because the claimant did not file a timely appeal using one of the several available methods, her appeal is late, and we do not have jurisdiction to consider the underlying merits. We should affirm the AT decision, late claimant appeal, voluntary leaving, no chargeback.
Reverse the AT, timely claimant appeal, resubmit.
We will resubmit the case.
Case number 3187988, Commissioner Alvarez.
The decision is not supportable. The last work from which the claimant separated before filing his claim was LEU named on the claim. The claimant named his correct last work. Regarding the separation, the determination is correct. The employer has provided inconsistent statements to TWC. The best evidence in the information provided to TWC when the claimant initially filed a claim involving his separation over a year prior to his claim. The claimant stopped working his assignment when the pandemic began because the client did not feel comfortable. The claimant contacted the employer and no assignment was offered. Later, the claimant was offered a position that would have required him to work with a nurse that dealt with COVID-19 patients. The claimant declined to work because of the risk of infection, but would have accepted other work. No other work was offered. Since the separation was caused in part by the pandemic, I can agree to protect the employer's account. Reverse the AT, correct last work, no misconduct, no chargeback, disaster.
We should reverse the appeal tribunal decision because the claimant named the most recent job separation prior to the filing of his initial claim. The claimant named the correct last work. As to the job separation under the home health precedent, the employment relationship continues until one party clearly notifies the other that the employment relationship is ended. Here, the claimant initiated the job separation when he rejected a job assignment. Because the claimant rejected the assignment due to generalized fear of COVID, he is considered to have quit without good cause connected with the work. We should reverse the AT decision. The claimant named the correct last work, voluntary leaving, no chargeback, adequate employer response.
Affirm the AT, incorrect last work, void the separation and chargeback determinations.
We have a majority vote that the correct last work was named. We do not have a majority vote on the merits.
I'm going to read it into the record mine, and I'd like to hear the chairman's vote as well. Voluntary leaving, claimant named the correct last work, voluntary leaving, no chargeback, adequate employer response.
That's what I have as your vote.
Okay, thank you.
Affirm the AT, incorrect last work, void separation and chargeback determinations.
Yes, sir.
And we're going to agree with Commissioner Alvarez on pay and protect. I believe his was a disaster vote, if I'm not mistaken.
Thank you. The majority vote is correct last work was named, pay and protect disaster.
Short form dissent.
Yes, sir. Thank you. And that was the last court case on docket 30. You should have received the UI short form dissent list for docket 30.
I move we accept staff recommendations on the remaining UI cases on docket 30.
I second the motion except for those cases on which I'm dissenting as reflected on UI short form dissent list for docket 30.
Concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 30.
Motion passes with the exceptions noted.
Thank you.
Thank you, guys.
Commission stands in recess.